Jury trial in South Korea was introduced in 2008 under the name of Civic Participation in Criminal Trials. It makes a system of a jury trial and a bench trial that judges make all decisions based on the verdict rendered by public jury. The purpose of trial is to punish people who commit a criminal act against society, but the most important aim of jury trial is to encourage people's active engagement in decision-making processes in the legislature, the administration, and the judiciary. In a sense, jury trial, which used to be presided by only a few trained professionals, gives the public an opportunity to have their voices in making significant life decisions for one of their social members. Introduction of jury trial changes the layout of courtroom to create a more democratic environment. Witness goes near the judge. Prosecutor and solicitors moves toward the gallery where the public sit. The accused shifts its position next to the solicitor to film support. And the 7 juries and 1 shadow jurors takes their place between judges and prosecutors. The problem is jury panels, as non-legally trained members, experience several difficulties in understanding dispute, evaluating the evidence presented, deciding on the facts, and making decisions in accordance with the rules of law and their jury instruction. Even though Supreme Courts provide the public with the diverse formats of materials such as online handbooks, webtoons, instruction videos, and leaflets depicting trial procedure or roles of jury, in aid of jury having a good grasp and delivering the right verdict, it is not easy to succeed in finding the facts and applying them to the relevant statute or law in an environment in which abundant amount of verbal and text information provided by judicial official persons overflows. Due to courtroom's unique environment that people gather and discuss on the subject matter which happen outside of the courtroom, public jurors who haven't experienced the system find it confounding and depend solely on photo, video, verbal statement, and written document to understand all the information regarding to criminal case and its legal processes. This is a story about the accused A. He'd been suffered from schizophrenia and hospitalized for 2 months. Even after being treated, he was under the delusion that his sister was monitoring him with stalkers and criminal hackers. His delusion made him run away from home and live on the street for over 8 months, but he ended up deciding to murder his sister. Mr. A went home, pulled out a kitchen knife, locked up the room door, and stabbed his sister several times till she died. Right after the crime, he asked his another sister to call police, and the police handed over the case to the court, in which judges and prosecutors were interrogating him to understand whether trials are necessary or not. One of the prosecutors in the fishbowl claimed for a trial and indict Mr. A as a murderer. On the court approval of her prosecution, 2 prosecutors and 2 solicitors in charge of the case started collecting and sharing all the documentary evidences, such as police statement, medical certificate, and witness statement. The prosecutors asked for more evidence from the accused and his solicitors because he insisted the time of crime was far from when Mr. A received mental health treatment. Day 7, the two solicitors submitted a statement of argument specifying the opinions of Mr. A to the court. The statement was reviewed by a court counselor, and she submitted it with all the litigation records to the judges who are responsible for the case. The judges, looking through all the documents, made up their mind to schedule trial date and made the prosecutors, solicitors, the accused, and the other related people, such as witness and the family of the accused, informed of the pre-trial. The pre-trial gave chances to discuss about all the evidences they had shared and the proceedings of this case before the trial. A few days before the trial date, the accused A requested jury trials as his solicitors and he believed the empathetic engagement of jury could help to reduce the sentence. As requested, jury selection had been proceeded a few hours before the trial started. Questions were overflowed to sort out jury panels who are as impartial as possible. The trial had begun. Judges began the trial by explaining the overall content in simple terms to bring about a better interpretation for jurors. It was followed by prosecutor's statement, solicitor's statement, witness testimony, and solicitor's final statement. In order to deliver the final judgment, all the 7 jury moved to the jury deliberation room to discuss whether Mr. A is guilty or not, and if so, what punishment would be appropriate. Even the judges gave an instruction what kind of punishments are generally given to this type of crime, they couldn't unify their opinions. 4 people said 3 years of imprisonment, 2 said 3.5 years, and 1 said 5 years. Trial was resumed after 3-hour jury deliberation, and the court chief judge delivered the final verdict. And the accused is be sentenced to 4 years of imprisonment with medical treatment. Attachment order for petition tracking overruled. Courtroom can be seen as one virtual space that is disconnected from other spaces, yet exists in the information-rich environment. All the information coming from outside of the courtroom are accumulated throughout a set of procedures for court trial preparation. It's from crime scenes, courthouse, offices, private rooms, hospitals, and to name but a few. The process of information seeking and searching in this virtual space varies considerably from person to person. To someone who are unfamiliar with the gathering, courtroom might seem a blended space full of desks and chairs. To someone, courtroom might be a reservoir of evidence and story. Considering jury trial is to encourage public engagement in legal decision-making, how can the space help civil jurors to grasp the evidence and render the right verdict? What if the newcomers can enter the accumulation of stories? What if they can experience the case as if it's happening to them beyond observing all the procedures?